Hi, everyone. So I've just gotten the clear to start pre-trial. Could I have introductions, please, from the prosecution in this case? Just an attorney from the prosecution? Yes. Hi.
Hi. Sorry, my internet. Please bear with me.
Of course.
Good morning, Your Honor.
Good morning.
May we make appearances before the court?
You may.
My name is Anna Gray, and I am joined by my co-counsel, Joy Song.
Good morning, Your Honor.
And Kennedy Johnson.
Good morning, Your Honor.
We represent the state of Midlands in this case. The prosecution has a few pre-trial matters we'd like to attend to. First, we'd like to invoke Rule 603, the constructive swearing in of all witnesses.
Okay, all witnesses will be considered sworn.
Next, we'd like to invoke Rule 615, the constructive sequestration of all witnesses bearing party representatives. The prosecution has no party representative.
Okay, defense, when you make your appearances, I'll ask if you have a party representative, but that rule is invoked.
Thank you, Your Honor. Given this is a Zoom trial, we'd like to know Your Honor's preferences by asking for permission to screen sharing documents with the witness, Your Honor, and the jury.
You don't have to ask my permission to screen share. I will assume that I am the only one seeing a screen share, that the jury can't see it. If you are trying to publish evidence to the jury, then you would ask permission and your opposing counsel would get to object if they would like to do that. But don't have to ask my permission to share it the first time.
And with that, the prosecution is ready to proceed to opening statements. Thank you, Your Honor.
Excellent. Defense, do we have appearances?
Yes, permission to make appearances before the court.
Granted.
Good morning, Your Honor. My name is Andres Baeza, and along with my co-counsel, Kendall Williams.
Good morning, Your Honor.
We are representing our client, Jordan Ryder, in today's matter.
Good morning, Your Honor.
Good morning.
Your Honor, we believe that all pretrial matters have been attended to, so with that, the defense is ready to proceed.
I have one question, counsel. Is Jordan Ryder your party representative?
Yes, Your Honor.
Okay, so we will not consider her sequestered. All other witnesses have been considered sequestered, and I'm ready to hear opening statements.
May it please the court. July 14th, 2018 should have been a regular day. A day that a mother and her 12-year-old daughter should have spent making happy memories. Instead, July 14th ended with the defendant being so angry and a 12-year-old Parker Page being found dead at the bottom of a 40-foot cliff. A mother is supposed to love and protect her daughter, not end her life. In a moment of rage, the defendant crossed a line that could never be uncrossed. She shoved her daughter, Parker Page, off of a cliff, where she plummeted to her death. And instead of protecting her daughter from all the evils of this world, the defendant made it so that Parker would never have a chance to experience everything this world has to offer. Parker Page has something called brittle bone disease. This disease caused her to have very fragile bones that broke very easily and frequently caused her pain. She also had severe asthma. Parker heavily relied on a hiking stick to walk because of an injury that occurred before her and the defendant even started the Crown Loop hike. The fact that Parker needed to use this hiking stick just made the defendant so angry. She was a 12-year-old girl who didn't want to go on a hike and was already in pain, so you can probably imagine that there was a lot of attitude and complaints coming from Parker. All the defendant wanted to do was go on an adventure with Parker Page, and to the defendant, all Parker was doing was ruining everything by complaining. Rage, disappointment, and resentment. All of these things contributed to the defendant reaching her breaking point. The defendant was just so angry. As the prosecution, we have the burden of proof. We need to prove beyond a reasonable doubt that the defendant killed her 12-year-old daughter, Parker Page. We, the people of the state of Midlands, will use the evidence and the testimony of our two witnesses to show that the defendant was angry with Parker Page on July 14th and showed clear signs of guilt after Parker was found. Today, you will first hear from Detective Chesney, the head investigator of Parker Page's murder. The detective would testify to the napkin found in the defendant's pocket the morning of July 15th. This napkin will have statements directly related to the death of Parker Page, wondering whether to call 911, saying this horrible ordeal was an accident, and apologizing for being so angry. You'll learn from the detective that this napkin was written by the defendant before she was interviewed by the police and hours before Detective Chesney found Parker's body. Finally, you will hear the testimony of Kelly Dews, who was also hiking the Crown Loop and will testify to having listened to and seen Parker Page and the defendant arguing on the Crown Loop. Through Kelly Dews' testimony, you will hear about the near constant fighting between the defendant and Parker Page. Fighting that eventually turned violent when the defendant yanked the hiking stick out of Parker's hand and jabbed it at her. Finally, you will listen as Kelly Dews recalls the last conversation she had between the defendant and Parker. A conversation that ended with Parker yelling at the defendant that she wished that the defendant had never gotten out of prison, followed by a scream. A scream that had to have been Parker. You'll hear all the evidence from today's trial, and you'll know what's reasonable and what's not. At the end of this trial, my co-counsel, Joy Song, will ask you to find the only verdict that the facts will support. To find the defendant guilty of aggravated murder. Thank you.
Thank you, counsel. Does defense have an opening statement?
Yes, Your Honor. May it please the court?
Mm-hmm.
Self-defense at a mother's expense. In 2012, Jordan Ryder was convicted of a few crimes that landed her in jail. Finally, 6 years later, after ample time and patience, as well as many meetings with the social worker, Kai Washington, Ryder was released early from prison and put on probation. Parker Page, Jordan Ryder's late daughter, was at the time in custody of Jordan Ryder, as well as Corbin, a sibling of Jordan Ryder. 6 weeks prior to her release, Jordan decided that the two of them would go on an adventure together on Calkins Campground. They arrived and met with Armani Rodriguez, who set them with their campsite number 12, which is secluded and the perfect place for the two of them to have some bonding time. Once they got settled in, they headed out on a hike on one of the trails. At this point, Jordan and Parker are at odds with each other and are not progressing much on their hike. In order for Jordan to help her daughter calm down, she decides that they will head back to their cabin. However, when they get to the cabin, the fighting does not cease. That night, around 2 a.m., the two were still fighting. Jordan decided that Parker needed a break, so she let her go out on a walk. So Parker set out on the trails by herself. In order for Jordan to ensure the safety of her child, she decides to go after her, following the trail Le Crown Loop, as it is the only one Parker is familiar with. When Jordan catches up to her daughter, Parker appears to be crying. When Jordan tries to comfort Parker, the young teen instead pushes Jordan away and says, "I hate you. You are ruining my life. I wish you were dead." Momentarily, the two are wrestling in each other's arms. When Parker ultimately pushes Jordan so close to the cliff that she fears she might fall off, Jordan tries to pull herself and Parker closer to the inside of the trail. However, Parker loses her balance and falls down the cliff. Self-defense at a mother's expense. Jordan starts to panic. After the death of Parker Page, you will hear that Jordan Ryder acted irrationally. All of the actions that happened prior to this devastating accident were simply results of stress, panic, and guilt, not caused by murdering someone, but by witnessing the death of her own daughter. We as a defense are not obligated to present you with any facts or witnesses, but we will. It is the prosecution's job to prove Jordan Ryder is guilty of knowingly and intentionally causing the death of her daughter. If you have any doubts by the end of this trial that Jordan Ryder did not murder her daughter, you must find her not guilty. Today, we will be calling two witnesses. First, we will hear from Cameron Lee. He will inform you that one of the key witnesses in this trial is in fact not trustworthy. The second witness we will be calling today is the defendant, Jordan Ryder. She will tell you that the death of Parker Page was simply an accident. This is a case of self-defense at a mother's expense. For this reason, after you have heard all of the evidence at the end of this trial, we will ask you to return with a verdict of not guilty. Thank you, Your Honor.
Thank you, counsel. Now that we are done with opening statements, I will let you all proceed to witnesses. So I'll let you get your time to set up, but whenever you're ready, the first prosecution witness, you can introduce yourself and begin testimony.
Thank you, Your Honor. Please, the court.
Yes.
The prosecution calls Detective Jada Chesney to testify.
Detective Chesney, you may take the stand and you're presumed sworn.
For the record, Your Honor, my name is Andres Baeza, and I will be conducting the cross-examination of this witness.
So noted.
Please state your name, Detective.
Hello, my name is Jada Chesney.
What is your job experience?
I'm a detective with the Midland Center Police Department, as well as the sworn law enforcement officer for the City of Midland Center. After being sworn in, I was assigned to East Sector Patrol, in which I worked for 8 years in uniform patrol. I made many arrests. I completed my ride training. And in 2016, I was promoted to the MCPD Major Crimes Division. And in 2017, I became a member of the International Homicide Investigators Association and completed their Basic Homicide Investigators course.
How long have you been working as a detective?
I've been working as a detective for 5 years and as a police officer for 13 years. I met my husband, actually, while I was in the academy and had my daughter when I first became a detective. Everything that I've done has been for her and our community.
Wow. In your experience, can you give us a rough estimate of about how many people you have interviewed in your career as a detective?
Wow, I'd have to think. I'd definitely say over 1,000 people.
When did you interview the defendant?
I asked Jordan Ryder some questions when I first arrived at the campsite, but I officially interviewed her July 15th, 2018.
What did the defendant say once police had arrived on site?
Well, Ryder was very nervous while talking to me, shaking and saying a lot. She said that she took Parker on this camping trip to help her recover by empowering her. And she said that Parker had gone missing and that she had no idea where Parker was.
Did the defendant call 911?
No. She expressed that she had been afraid to call 911 because of her criminal history and that she thought taking Parker camping was a violation of her parole agreement. I had received a missing persons call from Parker Page's legal guardian, Corbin Dallas. And after talking with Mr. Dallas, I tracked Parker Page's phone, and that's what led me to the Calkins campground.
Okay, now let's talk about your interview with the defendant. During your interview, how did the defendant describe their relationship with the victim, Parker Page?
Ryder said that she loved Parker a lot. Parker often wrote letters to her, and that was really the only thing that kept her going and kept her motivated to stay out of prison. And she hated the fact that Parker was staying with her brother Corbin, and the first thing she wanted to do was get Parker away from Mr. Dallas when she got out.
During this interview, can you describe the mannerisms and perhaps the body language and behavior of the defendant?
Yes. Ryder seemed distraught, and she wouldn't meet my eye. And as the interview went on, her body language mirrored less of a mourning parent and more of what I've seen in a very nervous suspect. And when questioned about the hiking staff, for example, Ryder started stuttering in her sentences, and she didn't want to answer many questions about it.
So did any evidence come up during the interview with the defendant?
Yes. We talked about the insurance policy, Parker's walking stick, and the napkin that I found in Jordan Ryder's back pocket.
During your interview,
One moment,
what did the
counsel.
defendant?
I've just received a message from the from defense counsel that he was trying to object, but the microphone wasn't working.
Well, I raised two objections, and I don't know if it wasn't coming through right or something with the audio.
I did not hear any objections.
Yeah, so microphone gave out for a moment. I refixed it.
So, counsel, if you remember what you objected to, we can do that objection now.
I don't remember. I got freaked out from the microphone breaking.
You don't remember? Okay. So going forward, okay. I will note that you were trying to make objections, and if you would like to raise more objections later, I will hear them. If you remember what they were, we can have a sidebar at the end of the testimony. How's that? Okay. And if there's anything that gets stricken, we can consider it stricken. Otherwise, I'm going to let the testimony continue. And like I said, defense counsel, feel free to raise more objections as it goes on.
Honor. Detective, during your interview, what did the defendant say about brittle bone disease?
Jordan mentioned that Parker had brittle bone disease and that she was diagnosed right after Jordan was sent to prison. Jordan told me that Parker had the least dangerous kind, I believe type 1, and Parker could beat it. She thought that she could overpower it or that it would go away when Parker got older.
What tool did the victim, Parker Page, heavily rely on?
Parker heavily relied on the walking stick that I just mentioned.
Would you recognize a picture of that walking stick?
Yes, I would.
Would you mind screen sharing that walking stick? Thank you. Is this the walking stick that the defendant referenced?
Yes, it is.
Is this a fair and accurate copy of a picture of the walking stick in question?
Yes.
Has it been changed or altered in any way?
No, not that I can see.
Your Honor, prosecution offers Exhibit 17 into evidence.
Does defense counsel have any objections to this being entered?
No objections, Your Honor.
Then it will be entered.
Thank you, Your Honor. Detective, can you explain to the court what the defendant said about the walking stick?
Ryder said...
This question calls for hearsay.
All right, I did hear that objection. Counsel, can you explain what you mean, or sorry, what are the grounds that you're objecting to, and what particular testimony are you concerned will be hearsay?
I'm objecting to hearsay rule 803 that this question calls for hearsay, as opposing counsel has asked what an individual stated about this walking stick.
Prosecution counsel, do you have a response to that objection?
Yes, Your Honor. This was a party opponent statement, and it is admissible in court, thus, because it was what the detective will be talking about is words from the defendant.
All right, so that is my understanding as well. By Rule 801, defense counsel, you're correct that they are asking for an out-of-court statement for the truth of the matter asserted. However, as Attorney Gray pointed out, under 801D, that is your party opponent today. So her testimony and her testimony alone will be allowed today. If you believe they're trying to bring in somebody else's testimony, feel free to re-raise your objection, counsel.
Yes, Your Honor.
Continue, Your Honor.
Yes.
Thank you. Sorry, Detective, can you explain what the court, can you explain to the court what the defendant said about the walking stick?
Yes. Ryder said that she did not want to buy the walking stick and that it made her angry that Parker even wanted the walking stick in the first place. However, she bought it anyway for the sake of the trip, and she thought that she would just show Parker that she didn't need it later on.
Okay, I'd like to circle back and talk about another piece of evidence that was brought up during the interview. Detective, did the defendant ever explain to you the napkin that you found in her back pocket?
Yes, but only briefly. When I asked about what was written on the napkin, she abruptly ended the interview.
Would you recognize a picture of that napkin today?
Yes, I would.
Co-counsel Joy Song, would you mind screen sharing that napkin? Is this the napkin that you found in the back pocket of the defendant?
Yes.
Is this a fair and accurate copy of a picture of the napkin that was found, of the napkin in question?
Yes.
Has it been changed or altered in any way?
No.
Your Honor, prosecution offers Exhibit 26 into evidence.
Defense, do you have objections to this being entered?
No, Your Honor.
Okay, it is so entered.
Thank you, Your Honor. What is this? Detective, can you explain this napkin?
Yes. This is the napkin that I found in Jordan Ryder's pocket the night I arrived at the camp.
How do you know it was the defendant's napkin?
I found this napkin when I first arrived on the scene, and during the interview, Jordan was able to identify this napkin and confirm that it was her own handwriting.
Can you read what the phrases under 911 says?
Yes. The first one says, "I'm so sorry this happened. It was all my fault." The second and third ones say, "I was just so angry and I didn't mean to do it." The last phrase says, "missing."
Where did the defendant say that Parker Page was when the police arrived on the scene?
Jordan said that they got separated and that Parker went missing.
What phrase out of the 4 phrases found on the napkin is circled by the defendant?
The last phrase on the napkin is circled, saying "missing."
Thank you, Detective. No further questions, Your Honor.
Thank you, counsel. Defense, I understand that there will be cross-examination of this witness.
Yes, Your Honor. However, I would like to re-raise some of the objections that I missed from when my microphone gave out. I objected to a speculation that the detective was using as they stated that my client, Jordan Ryder, was nervous during their first interaction.
All right. So the speculation objection is to specifically testimony by Detective Chesney that the defendant was nervous. Do I have that right?
Yes.
Prosecution counsel, do you have a response to that objection?
Yes, Your Honor. The detective was not speculating anything. The Detective Chesney, was merely observing the behavior of the defendant.
Your Honor, may I be heard?
Could I, before you are heard, could you remind me, and you can call Detective Chesney back to the stand if necessary, what exactly she said about her perceptions of the defendant?
Yes, Your Honor. If I am correct, I think
I can restate.
That would be great, detective. Just to hear what exactly the words were.
Yes. Well, I said when I first arrived at the camp, when I was talking to Ryder, she was shaking and she was saying a lot and she was stuttering. And during the interview, Ryder seemed distraught and she wouldn't meet my eye. And as the interview went on, her body language mirrored less of a mourning parent and what I've seen in a very nervous suspect. I was merely observing her body language.
All right. So Attorney Baeza, was your objection specifically to mirrored what I've seen in a nervous suspect, that language?
My language, yes, that language. My issue was that this comes from the opinion of a lay witness. As a Detective Chesney does not have any degrees in psychology or analyzing body language and cannot testify as to whether this specific body language is in line with someone who is nervous.
Prosecution counsel, do you have a response on those grounds?
Yes, Your Honor. Detective Chesney has been a detective for several years and has interviewed, as you heard in their testimony, over 1,000 people. They have adequate experience in this, and they have encountered many innocent people and many guilty people. It's merely an observation and them forming an opinion based on the history and the experience that they have.
Your Honor, may I be heard?
Yes, briefly.
Opposing counsel just stated that this was in fact an opinion in my issue, that this is an opinion from a lay witness. Although Detective Chesney does have experience as a detective, this is still opinion testimony from a lay witness regarding another person's actions. As Detective Chesney does not have expertise from a medical degree and is not an expert witness in today's case, they cannot use their opinion testimony as to testify to the body language of my client and whether this is in line with them being nervous.
So here's what I'm going to do, counsel, just to wrap this up. I tend to agree that we have not laid the foundation that Detective Chesney has, some kind of career experience that allows her to know how people are feeling. So I'm going to strike one word from the record based on that objection, and that word is nervous. The language I understood it was her body language mirrored other nervous suspects. I think it's well within the perceptions of the detective to say that the defendant's body language mirrored other suspects she's seen, that the defendant wasn't meeting her eye. That's all going to remain on the record. The word nervous will be stricken for lack of foundation to how she would know that. And both of your arguments are well taken in this case.
Thank you, Your Honor.
Thank you, Your Honor.
With that, are you ready to proceed to a cross-examination?
Yes, Your Honor. Okay. Detective Chesney, I would like to ask you some questions regarding your experience as a police officer. Detective Chesney, you became a police officer in 2008?
Yes.
And you spent 8 years as a sworn police officer in uniform patrol?
Yes.
And it's my understanding that in these 8 years, you had the responsibility to take on traffic violations.
Yes. And
now,
I completed many arrests.
Thank you. Now, you didn't become a detective until 2016. In fact, Detective Chesney, you only completed the basic homicide investigators course in 2017.
Correct.
This would mean that you have had at most 1 year's worth of experience as a detective before the potential homicide case that's at hand today.
I've been a detective for 5 years.
Okay, Detective Chesney, I asked you if that meant that you would have had 1 year's of experience before the case at hand today.
Correct.
Thank you. Now, I would like to ask you some questions about how you interpreted this case, Detective Chesney. You originally spoke and believed that this case at hand was a missing persons case, correct?
Correct.
And you also changed your theory that this was then, in fact, a kidnapping case.
Correct.
And you believed that Parker Page was the individual who was kidnapped?
Correct.
The suspect of this kidnapping was Miss Ryder, correct?
Correct.
This is the Jordan Ryder who was Parker's mother?
Correct. But
This
her
is-
legal guardian was Corbin Dallas.
Thank you. This is the Jordan Ryder who is Parker's only living parent, correct?
Correct.
And this is in fact the Jordan Ryder who had complete parental rights of their child Parker?
Correct.
Now, Detective Chesney, your kidnapping theory was incorrect.
Are you asking?
Yes.
No, and her Parker Page's legal guardian was Corbin Dallas. Jordan Ryder.
I'm sorry, Detective Chesney, you just testified that Jordan Ryder had complete parental rights over Parker Page, correct?
Corbin Dallas had parental rights.
Okay, Detective Chesney. You do remember the
Objection, Your Honor.
On what grounds, counsel?
Relevance.
Which testimony specifically are you objecting to the relevance of?
The relevance of the kidnapping.
So, Attorney Baeza, what is the relevance that you're of what you're eliciting here with the kidnapping?
Yes, Your Honor. Actually, this testimony is incredibly relevant as it will be used to show that I was just about to impeach the witness. They were in fact aware that Corbin Dallas only had residential custody while Jordan Ryder was in prison, and that while that happened, Jordan Ryder still had complete parental rights over Parker Page, as Detective Chesney had already testified in my cross-examination. I was going to use this testimony to question as to whether this kidnapping theory was even plausible, as Jordan Ryder was the only sole living parent of Parker Page and had the complete parental rights of Parker Page. This testimony is incredibly relevant in today's case, as it goes to show the events of what happened and how they were completely allowed and legal up to this point.
Your Honor, may I respond?
Yes, prosecution.
The Corbin Dallas had guardianship over Parker Page. The defendant was just before Parker Page's death had just been released from custody for around 6 weeks. The detective is testifying to the best of their ability, and the relevance of this has nothing to do with the death of Parker Page.
So both of your arguments are very well taken. The charge in this case is not kidnapping, it is murder. That being said, I do think, given that this detective was the primary detective on the case, and that she has just testified with a considerable amount of evidence in this case, I do believe that what the defense counsel is doing in questioning her methods and the credibility of the detective as the finder of fact in this case is relevant. I would empower you to re-raise the objection if you feel that this line of questioning is going on too long or is misleading. But I'm going to overrule the objection now and allow the testimony to continue.
Thank you.
Your Honor?
Yes, you may continue.
Okay. Detective Chesney, you remember the deposition between you and Jordan Ryder, correct?
Correct.
Your Honor, I request permission to present the deposition.
Yes, you can screen share the deposition.
All right. Detective Chesney, you're seeing the deposition now, correct?
Correct.
Now, if you could please read along silently to yourself as I read to the court. But I mean, you still had parental rights and everything, right? It was just a residential custody. Thing, Ryder, yes. Do you recall this?
Yes.
So you would agree that Jordan Ryder had complete parental rights over Parker Page?
Yes, once she got out of prison.
So now my question is that your kidnapping theory was incorrect.
Correct.
Thank you. Now, Detective Chesney, I would like to discuss some of your interactions with Corbin Dallas. Detective Chesney, when you located Parker, you simply tracked her eCloud account, correct?
Correct.
So you used this eCloud software to track her?
I issued an Amber Alert, but yes, used the software to.
And this was using this software over police technology.
Correct.
Now, this idea was not in fact your own.
And why would it not be my own idea to try to find?
Detective Chesney, was the method in which Parker Page was tracked recommended to you by someone else?
Yes.
And you spoke to Corbin Dallas?
Objection, Your Honor.
Yes.
I object to Rule 403, more prejudicial and probative.
Can you say a little bit more about that, counsel?
Yes, Your Honor. Sorry, the attorney Baez, I'm sorry if I mispronounced your name. They are bringing into case whether it was Detective Chesney's idea or not to track Page, the software that they use to track her, and this is trying to prejudice the jury against Detective Chesney, and it's not important to the murder or the death of Parker Page in this case.
Okay, so what I'm hearing is that it's a 403 objection, that this line of testimony is significantly more, substantially rather more prejudicial and probative. Defense counsel, what is the probative value of this line of testimony, if I may ask?
Yes, Your Honor. The probative value of this testimony is to show how Detective Chesney was informed of this method of tracking Parker Page, where they would get to the campsite where they ended up finding the body, which is incredibly relevant in court today. In addition, it goes to show how there may have been issues in which they were recommended this method by the individual who recommended it, Corbin Dallas, who we will go into more in my line of questioning.
All right, I might ask you, defense counsel, for an offer of proof as to the relevance of Corbin Dallas having been the one to bring that up to Detective Chesney.
Yeah, my offer of proof is that at the time of this incident, that the Corbin Dallas was intoxicated when this was delivered to the police officer, which could draw as a major event in the occurrence of this case and finding the body, and how it was located, and all information delivered to Chesney before Parker was found. It was delivered from this intoxicated individual.
Okay, you have presented me with a really interesting series of arguments. Yes, prosecution, continue.
That in itself is more prejudicial than probative, because to say that they were intoxicated is prejudicing the jury against alcoholism and trying to incriminate and villainize someone that's not even a part of this case today. The way that the police tracked to find where Parker Page and the defendant were staying at the campsite it's not important to this case and what the defense's theory of the case is, nor to what the prosecution's theory of the case is.
All right, so you've just done something really interesting to me, counsels, because I did not frankly understand how this was either prejudicial or probative, and now you have shown me that it is in fact both. For the sake of this case, what I am going to do is say that this is a matter of weight and not admissibility, meaning that I'm going to let the testimony in, so I'm going to overrule the objection, but I will be instructing the jury to be very careful how much weight they give to the notion that Corbin Dallas was drunk when they suggested the Find My Phone or tracking to the detective.
Thank you, Your Honor.
Thank you, Your Honor. So, Detective Chesney, you spoke to Corbin Dallas when you were first investigating whether Parker Page was missing, correct?
Correct.
And you are familiar with the fact that Corbin Dallas is a drug abuser?
Drug abuser. I was informed
Objection.
Yes, counsel.
Lack of personal knowledge.
Your Honor, if I may be heard.
In terms of personal knowledge, I'm going to give a little bit of leeway for defense counsel to lay that foundation. Feel free to re-raise the objection if you think they move on without laying that foundation.
Thank you, Your Honor.
I'm sorry, may I proceed? Your Honor, may I proceed?
Yes.
Detective Chesney, Corbin Dallas is a drug abuser, correct?
correct.
And in your case investigation report, you said that they were flagged with drug addiction under the police records.
Yes, correct.
You also stated that they were flagged with an alcohol addiction in the police records, correct?
Correct.
When you spoke to Corbin Dallas, they were intoxicated.
Are you asking?
Yes, Detective Chesney.
I'm not sure whether Corbin Dallas was intoxicated or not when I spoke with him.
Okay. So, Your Honor, I'm going to be presenting the case investigation report.
All right, you're going to be screen sharing that?
Yes, I
All right, you can proceed to that screen share.
apologize. Share screen. Detective Chesney, can you see that your case investigation report?
Yes.
Now, you recognize that this is your case investigation report?
Yes.
And you swore to include all relevant information in that report, correct?
Correct.
Now, Detective Chesney, it appears to be a true and accurate copy of this case investigation report.
Correct.
Please read along silently while I read aloud. I noted the odor of intoxicants on Dallas's breath. Dallas's eyes were bloodshot, but his speech was not slurred, nor was Dallas sane or swaying or unsteady. Dallas stated that Dallas had been extremely intoxicated last night and, quote, may still be a little this morning, but denied drinking more today. Is that correct?
Correct.
Okay, thank you. Now, you even noted the odor of intoxicants on Dallas's breath.
Yes.
You said that Corbin Dallas's eyes were bloodshot.
Yes.
Corbin Dallas also told you that they were, quote, extremely intoxicated the night prior.
Yes, the night prior.
And Dallas had even said to you that they were still intoxicated that morning.
Might have been, correct.
Now, Detective Chesney, in your search for a missing Parker Page, it was this intoxicated individual that had to recommend tracking Miss Page's phone in order to find her.
Correct.
Thank you, Your Honor. No further questions at this time.
Is there any redirect examination of the witness, Attorney Gray?
Can I redirect the questions, Your Honor?
You may.
Thank you, Your Honor. Detective? I'm sorry, can you hear me?
Yes, I can.
Okay. Detective, during this investigation, did you perform this investigation to the best of your ability?
I'm sorry, I couldn't hear you on the last part of your sentence. Can you repeat that?
Yes. Did you perform the investigation into Death Park to the best of your ability?
Yes.
Did the police perform this investigation to the best of your ability?
Yes.
Your Honor, I couldn't hear opposing counsel Attorney Gray's testimony. Perhaps if they could just type it out into the chat for everyone to see, and it can be admitted to the record as if she stated that, simply for clarification.
That works for me. I can also, what I believe I heard was that first Attorney Gray asked Detective Chesney if she performed the investigation to the best of her ability, and then she asked Detective Chesney if the police performed the investigation to the best of their ability. Detective Chesney, were those the questions you were saying yes to?
Yes.
Okay. Yeah, going
Yes,
forward
and
though, sorry?
Your Honor, I have one more question, if
Yes.
it pleases the court.
And your audio is much clearer now, Attorney Gray.
Okay, sorry, I think I had to turn off my camera.
It happens.
Detective, did you use the evidence that you found to conclude with the most likely order of events of what happened in the case of the death of Parker Page?
Yes, I did.
Your Honor, this question is leading.
You are objecting to the question being misleading, counsel?
Yeah.
Okay. In what way do you believe that that line of testimony was misleading?
This line of testimony was not misleading. It was a leading question in a direct.
Oh, a leading question.
Yes, a leading question, as it implied the answer of whether they completed this to the best of their ability, and the simple answer that they gave was simply a yes.
I see your point. It's a well-taken point. However, just because something's a yes or no question does not necessarily make it leading, so I'm going to give a little bit of leeway.
Thank you.
Thank you, Detective, and thank you, Your Honor. There's no further questions
All
for the
right, thank you,
prosecution at
counsel.
this time.
Does the prosecution have a second witness?
Yes, Your Honor. We call to the stand Kelly Dews.
All right, Kelly Dews, you may take the stand and you have been presumed sworn.
Good morning. Will you state your name for the court, please?
Hi, my name is Kelly Dews.
What is your current occupation, Ms. Dews?
I am an influencer on MeTube with almost 4,000 subscribers. And just in case you're wondering, my channel is Kelly Dews Stunts.
Please let me know if you cannot hear me clearly. How are you involved in today's case?
I was at Calkins Campground on July 14th and 15th. I spoke to both Jordan and Parker, and I was also on the search party that found Parker.
Why were you at Calkins Campground?
Oh, a good friend of mine told me that I should check out some of the haunted campgrounds in Midlands.
And when did you arrive at Calkins Campground?
At around 1 p.m. on Saturday afternoon.
So what activities did you begin your Saturday afternoon with?
Well, I really wanted to get walking, so I started out on the Wagner Loop and headed to the Muskie Pond.
After the Muskie Pond, where did you head towards?
I had heard about the Lacrome Loop and I wanted to check it out, so I decided to head there. I started the trail at around 3 p.m.
How was your trip on the Lacrome Loop?
Everything was all right at first, but around 20 to 30 minutes in, I saw a girl and what seemed to be her mother.
Can you describe them?
The girl seemed to be around 11 to 12 and definitely did not seem to want to be there. She was whining and threshing a hiking stick around at bushes and branches. she also looked like she had a limp.
How did the girl's mother respond to this?
She glared at her daughter and yelled, "Quit it," a couple of times before, and looked at her in a very threatening way. The mother definitely did not seem to be in a good mood.
Were you able to get their names?
I remember the girl's name was Parker, especially because I have a cousin named Parker. The adult said Jordan was her name.
Do you remember anything else from your encounter with the defendant?
Well, I wanted to start up a conversation, so I told them to check out the Muskie Pond. And Jordan just kind of responded with, "Well, the way things are going with this kid's attitude, I don't even think we're going to make it up this trail." And right afterwards, Jordan just snatched the hiking staff out of Parker's hand and almost pulled her to the ground.
What happened afterwards when the defendant snatched Parker's hiking staff out of her hand?
He held the end of the hiking stick near Parker's left hip and made a jab towards Parker.
What were your thoughts about the defendant and her daughter?
Honestly, it made me really uncomfortable and I really wanted to get out of there. So I just decided to venture off the main path and head towards the lake for a while.
And did you ever return to the main path?
I returned after about an hour, so at around 4:20 p.m.
Did you encounter anyone as you returned?
Well, when I came back, I saw Jordan and Parker again in the exact same spot they were before, still arguing.
What was your second encounter like?
Listening to what they were saying, I heard Parker shouting something like, "I should have stayed home with Corbin."
Objection, Your Honor, hearsay.
Was it to the statement, "I should have stayed home with Corbin"? Just
Yes.
to clarify. Yes, would you like to be heard further on that point?
Well, the witness is talking about an out-of-court statement that has not been confirmed.
Okay. Attorney Song, would you like to respond to that?
Yes, this statement is not being offered for the truth of the matter asserted, simply so that we can tell what Jordan's response is to hearing what her child said. Simply here, we want to look at Jordan's response to hearing her child say that she would rather spend time with their brother Corbin rather than her.
All right. Attorney Williams, is it? Do you have a response?
Yes, Your Honor. Knowing what Jordan Ryder would say after that would also be hearsay.
Okay, so here's what I'm going to do with that. I tend to agree with prosecution counsel that the fact at issue is not whether or not Parker Page should have stayed home with Corbin Dallas. So if you have an argument on that ground, if you believe that that is being used for the truth of the matter asserted, I would absolutely re-raise your objection. Jordan Ryder's statements, as I previously ruled, are subject to 801D, which would define Jordan Ryder as the party opponent of the prosecution counsel. So any testimony they elicit regarding Jordan Ryder would be admissible to the record insofar as it wouldn't be considered hearsay. Does that make sense?
Yes, Your Honor.
Okay, so I'm going to allow you to continue. If defense counsel, like I said, if you believe that they are using this statement for the truth of the matter asserted as the testimony continues, feel free to re-raise the objection.
Miss Dews, how did you know it was Parker who said, "I should have just stayed at home with Corbin"?
I heard her say it just as they came into view, so I just barely saw her say it.
What happened afterwards?
I, again, really wanted to get out of there, so I started going up the path as fast as I could. And as I was going, I decided to turn around one more time, and I saw Jordan grabbing Parker's hiking staff once again.
How did you know that the defendant was grabbing Parker's hiking staff?
Well, I mean, it was the only large blue item in the area.
Where did you head towards next?
I decided just to head towards Calkins Rock. I was about 15 minutes up the trail, and then I started to hear some screaming.
Do you know where the screaming came from?
Yes, it came from behind me where I had just seen Parker and Jordan. And it was definitely Parker I heard scream. She has a very distinct voice. She screamed a bunch of stuff like, "I wish you never got out of prison. You love our stories more than the real me. I hate you."
And when did you hear this screaming?
At around 4:40 p.m.
Was there anything else?
I took a few more steps forward, and then I heard this really loud yell. It also seemed to come from Parker.
Can you describe your experience on Leckrone Loop?
It had quite a few dangerous drop-offs, and you could definitely get hurt if you weren't paying attention. The trail's pretty rocky, and it's very uneven. Definitely a trail for more experienced hikers.
Now, I'd like to turn your attention to July 15th. How did you spend the morning?
Well, I was organizing some of my pictures, deciding which stuff I needed to post, which stuff I was going to throw away. And at around 10 a.m., I started to hear sirens.
How did you react to the sirens?
I'll be honest, I got pretty curious. So I left my cabin and headed towards them. That's where I found a ton of officers. I met Detective Chesney, and she asked me about a missing child and showed me a picture of Parker.
What did you tell Detective Chesney?
I told her that I had seen Parker and Jordan on a trail the day before and offered to take her there.
Is there anything else you did as part of this investigation?
After showing Detective Chesney around the trail, she asked me to join the search party to look for Parker.
And were they able to find Parker?
Yes, but unfortunately we were too late. She was below the cliff.
Can you describe the surroundings of the child's dead body?
It was a very heavily wooded area and not an easy place to get to. And it was a 40-foot drop from the trail to her body.
No further questions, Your Honor.
Thank you, counsel. Is there cross-examination of the witness this time?
Yes, Your Honor.
All right, you may proceed when ready.
Ms. Dews, I want to walk through your first day at the campsite. You arrived at Calkins Campground on July 14th around 1 in the afternoon.
Yep.
And when you got there, you saw a sign that indicated for you to check in at someone's cabin.
Yes, I did.
Armani Rodriguez, right?
Of course.
However, when you got to the cabin, there was no one there.
Nope.
Instead of waiting for someone to arrive, you went ahead into the campground without paying.
Yeah, I came back and paid later.
Now, once you entered the campground, you grabbed a map and started exploring.
Yep.
You then took a break to eat lunch and started taking a few pictures.
Yeah, they were really good pictures.
You have multiple social medias, correct?
Yep.
These pictures were for those social medias?
Some of them were for the social medias. I've also been thinking about writing a book.
One of these social medias include the MeTube channel.
Yes.
On this channel, you have 3,800 subscribers, right?
Of course.
You do tend to exaggerate these numbers quite often so that you can generate better ad revenue, correct?
Just a little bit.
So after your lunch and taking these pictures, you set out for Leckrone Loop.
Yep.
The whole campground was pretty much vacant, correct?
Most of it was, yes.
However, you did see someone at the picnic tables right outside of the campground.
I did.
Your encounter with this hiker, it was just a simple nod?
Yep.
Once you left him, you kept on your journey to explore the lake, correct?
Yep.
While you were walking around, you encountered a pair walking in front of you.
Yeah. Jordan and Parker.
They were walking pretty slow and you caught up to them quickly.
Uh-huh.
And you do like to greet other hikers, especially when you are alone, correct?
Well, of course, I like being around company.
Was there anything in particular that helped you decide against greeting the hiker earlier by the picnic table?
Not really.
Now, I want to talk about the encounter that you had with these two people that you were coming up on. So the adult was the one that was talking the most, right?
Yep.
The child never spoke up?
Not really.
She never formed a full sentence?
No.
You couldn't even hear her very clearly.
Not very clearly.
Later on, did you have another encounter with the two?
Yes.
They were arguing?
Yep.
And this arguing, it escalated from simple arguing to even screaming at each other?
Yeah, it did.
Could you hear the two the entire time you were hiking past them?
Yep.
Could you see them?
For most of it, yes. I tried to turn my head away, though.
You're certain that it was them?
I am very certain that it was them.
Even after you reached the summit?
Yes, I'm very certain.
After you reached the summit, you then came back down to the place you recalled Jordan and Parker being?
Yep.
Around 5 or 6 o'clock?
Yeah, I wanted to look for them, make sure they were okay.
You then reached the campsite after that around 6:30?
Yep.
And you asked Armani about getting a cabin to stay the night?
Yes, I did.
Is this when you paid Armani?
Yeah.
After this, you drove into town and got some dinner?
Yeah.
You
It was
also
really good.
picked up a few things for breakfast afterward, correct?
I did.
In the morning after you arrived back, you did a lot of writing.
A lot of it, yeah. I like writing.
Then around 10 o'clock, you heard sirens.
I did hear sirens.
You also heard a bunch of police officers and first responders outside of your tent.
I did.
You joined the crowd.
Yep.
And Detective Chesney came up and asked you whether or not you recognized Parker.
Yeah.
You were then brought with Detective Chesney to the last place you saw Parker.
Yep.
You didn't find her there, though.
No.
And she was not directly below the cliff either.
Maybe not directly below, but very close to it.
Okay. So she was not directly below the cliff where you last saw them.
She was definitely below the trail.
So everyone was searching for her for quite a while before they actually found the body?
Yes.
You never actually saw the body, though.
I did get a glimpse of it.
So you didn't see the full body, but you were in the area in which they found the body, correct?
Yes.
And while you were there, you heard a few police officers talking about Jordan Ryder.
I did.
They said, "I can't believe Jordan Ryder would do such a thing."
I mean,
They
yeah.
also said, Jordan Ryder should have never gotten out, correct?
Correct.
At this point, did you have any suspicions that Jordan Ryder could have killed Parker because of the police officers?
Not because of the police officers.
Did you have any suspicions that Jordan Ryder had killed Parker?
Yes, I did.
So after they found the body, did you go back to the campsite?
Yes, to write an affidavit.
Were there any more questions, a lot of questions asked to you after this?
A few, yeah.
That's it, Your Honor.
All right, thank you, counsel. Prosecution, do you have any redirect of the witness?
No redirect, Your Honor.
All right, is there a third prosecution witness today or just two?
Just two.
All right, then. I think the prosecution for that case in chief, I will now allow the prosecution to rest that case in chief. And why don't we take a 7-minute recess before the defense case, if that's all right with all parties? Any objections to taking a recess?
None at all.
Your Honor.
Okay.
No,
so
Your Honor.
I have I don't know if everyone's in the same time zone, but I have the time as being 42 minutes after the hour. Let's convene at 49 minutes after the hour. It's 49. It is 49 minutes after the hour. So if I could get a heads up that at least my attorneys for the first defense witness and my first defense witness are here, we can get started. So defense, whoever your first witness is. Hello, Cameron Lee. I see that you are here. Would the attorney representing Cameron Lee let me know if you are here yet?
Kendall Williams is the attorney that is calling Cameron Lee to the stand, and I do not believe they have returned at the moment.
Okay, and from prosecution counsel, who is cross-examining Cameron Lee? Maybe someone else? Oh, yes?
Anna Gray. I don't believe she has returned that.
Okay, so we will wait for attorneys Gray and Williams.
Your Honor, I am actually not crossing this witness. My co-counsel Kennedy Johnson is supposed to be crossing this witness.
Is Attorney Johnson present?
Hello, Your Honor. I'm supposed to be crossing the defendant. Anna Gray.
Okay.
Oh, I'm sorry. I thought you said Jordan Ryder. My internet is really messed up. I apologize, Your Honor.
No worries at all. So Attorney Gray, you are going to be cross-examining Cameron Lee?
Yes, Your Honor.
Okay. And so we are now waiting for Attorney Williams, and then we will start the defense's case in chief.
I'm here, Your Honor.
You're here. Okay. So everyone relevant to the first part of the case in chief is here. I believe we can begin.
Thank you, Your Honor. Hello, Mr. Lee. How are you doing?
Hi, I'm doing great. Thanks for asking.
Can you introduce yourself?
Well, my name is Cameron Lee and I'm 25 years old.
I want to start with some background information. Where do you work?
I work for a local bonds person, Mr. Alexi at Out of the Blue Bonds. To tell you the truth, and I hope we can keep this a secret, it's a pretty boring job. I spend most of my time on the computer and I hate it. I'd much rather be outside. That's why I love camping.
How did you get into camping?
Well, it's because I had some arsonist tendencies as a kid. I loved playing with matches and lighting fires in the basement. And one day my mother caught me and she offered to take me out camping if I stopped playing with fire. We went camping that weekend and I found a new passion.
How long have you been camping?
For years, since I was about 9. I consider myself a bit of an expert. I've camped at almost every campground in Midlands, but my favorite has got to be Calkins Campground.
What is the campground like?
Calkins has so much beautiful nature and a great mix of trails. I love Calkins especially because of the people. You know, they're all such characters. And there's nothing better about, camping than being around people who are characters because they always have such interesting stories to tell.
And when did you last visit Calkins Campground?
The long weekend of July 13th to July 15th. I was taking a trip to Aruba on Sunday and I decided I wanted to get some camping in before I left. I haven't been back though since I found out that girl, Parker, died there.
That must have been hard on you. How did your last visit to Calkins Campground start?
Pretty normally. I got there on the 13th at about 7 p.m. I asked Armani Rodriguez, the camp manager, to check me into campsite 8. I paid for it, went to my site, set up, and then went straight to bed. I slept like a baby, and then I woke up early the next morning.
How did the morning of July 14th go for you?
I made myself a quick breakfast, and then I decided to do a little hiking. I hiked up to Peterson Point. The scenery, as always, was beautiful. And then I made my way back to Armani Rodriguez's cabin at around 12 p.m. And while there, I noticed a car driving on the road I was walking on.
Who was in the car?
There were two people in the car, a preteen girl and an older woman that I assumed was her mother. I now know that their names were Jordan Ryder and Parker Page.
Was this your first time seeing the duo on this campground before?
Yes, I assumed that they were novice campers. They were going to campsite number 12, which is pretty isolated and not a site experienced campers will go to. I waved to them and the girl, Parker, waved back to me. The mom just kind of pretended I wasn't there. And then afterwards, I just got back to my site and took a nap.
What happened after your nap?
I woke up at around 2. At about 2:30, I made my way to the picnic area around the bridge close to Le Grand Loop. I wanted to eat lunch, and after I ate lunch, I saw the duo from earlier, Jordan and Parker, walking towards me.
What were your interactions with the two like?
They seemed a lot more positive than before. Jordan was smiling at me as she approached, and Parker was behind her using a hiking pole. She was moving with a bit of a limp. They stopped to talk, and I introduced myself to them. We talked for a bit, and then Jordan called for Parker to hurry up so they could start hiking. Once Parker caught up, they left.
Did the two seem like they get along?
They seemed like a normal mother-daughter duo. They were both nice, and Jordan seemed excited to go hiking alongside Parker. I get why. The time I spent hiking with my mother forms some of my best memories of her.
What did you do after you all separated?
I stuck around for a while because I needed to clean up my picnic table. Some irresponsible hikers will leave around trash that attracts animals like bears. While I was cleaning up, another hiker walked on the trail next to me. We interacted a little.
How did your encounter with this hiker go?
It was honestly really weird. Like, I introduced myself to her, but she just nodded. And then she said Kelly before continuing on. It was very odd.
What did you do after you saw Kelly?
Well, it was around 4:30, so I went down to the musky pond and dipped my feet in for a few hours in order to cool down. From where I was, I had a good view of all the hikers coming and going up the path. There weren't a lot of people that day, and I didn't really pay attention to everyone coming and going, but I do believe I saw Parker and Jordan coming back.
Why did you assume it was Parker and Jordan?
Well, I definitely saw Jordan. She was quite visible when crossing the bridge. About 10 minutes after I saw her, I heard someone coming up behind her. I didn't actually see who it was, as by the time I turned to look around, the person was covered by trees, but I assumed it was Parker. In my mind, they had probably tried to go up Le Grand Loop, realized it was too difficult for them, and then turned back. I thought that Parker might have been stubborn and tried to continue because that's how I was when I was hiking as a kid.
After seeing and hearing these two, did you see anyone else that day?
A few other hikers, but no one of note. I got back to my campsite later that night, and then I just made a campfire, played some guitar, and went straight to bed.
How did you sleep that night?
I slept pretty well, at least until 2:30 a.m. when I was awakened by a light shining through my tent and what sounded like a thunderstorm. I got out of my tent, and while I could hear the clang of a truck going down the road, I couldn't see it in the night, so I just went back to bed.
When did you leave the campgrounds?
I left early on Sunday morning. I wanted to make sure that I'd catch my flight to Aruba. I got a ride to the airport and got on my flight.
Were you aware of what had happened to Parker at the time?
Not at all. I got on my flight to Aruba and I had a blast there. And then when I was coming back, I was pretty exhausted from all the flying. And, when I got back home on July 21st, that was when I first saw the news of Parker's death on a TV in the airport. When I saw the news, I immediately phoned 911. I couldn't sit around when someone had died.
And who are you put in contact with through 911?
Well, 911 got a couple of airport officers to pick me up. They took me to the police station where I met Detective Chesney, who interviewed me. I went home and slept, and then the next day they called me into the station again.
Why were you called into the station again?
They wanted me to do an official identification.
Did you make the official identification?
Well, when I got there, I was escorted to a room where I saw Jordan Ryder handcuffed. I told Chesney that that was the Jordan I saw at Calkins campground, and then they told me that they didn't need my official identification, and I was just thanked for my time.
What was your experience at this station like this time?
Well, it felt really rushed and almost unprofessional. It felt just weird of them to ask me to make an identification and not go through with it. Just seeing Jordan handcuffed and seeing that I was asked to identify him, I just assumed that they thought he was the killer and that they didn't even need my official information anymore.
Objection, Your Honor.
Yes, what are your grounds, counsel?
Improper opinion.
Can you explain a little bit more about what particularly you're objecting to and why it would be considered improper opinion?
Yes, Your Honor. The witness says that during this process at the police station, that it felt rushed and unprofessional, and that they were ready to arrest the defendant, and that they do not have the experience around any credentials or anything that to come and draw that conclusion.
Okay, so what I'm understanding, counsel, and correct me if I'm wrong because your audio cut out a little bit, is that it's improper for Mr. Lee as a non-police officer, somebody who has not laid any foundation that he knows how police investigations work, to be passing any kind of judgment on the quality of the investigation. Was that the objection?
Yes, sure.
Okay. I'm gonna have Mr. Lee repeat exactly what he said about that investigation before I continue with the objection arguments.
Okay, so you would just like me to just repeat what I said?
Yes, please, Mr. Lee.
Okay, so I just said, in my opinion, it felt really rushed. You know, it was almost unprofessional. It just felt weird of them, in my opinion, for them to ask me to make an identification and not go through with it. Seeing Jordan Ryder handcuffed there, I just assumed that they were pretty set on him being the criminal and that my official identification wasn't even needed.
Okay. I'm gonna do what I did before with the speculation objection. And I'm going to strike certain parts of your testimony, but not all of them. So certainly I'm going to strike any notion of unprofessionality. I tend to agree with prosecution counsel that this witness doesn't have enough foundation to know how police investigations work. I am also going to strike the word weird because, again, we have not heard foundation that this witness has basis for comparison to how a normal investigation works. What I will keep in is that he felt rushed and that he saw Jordan Ryder in handcuffs and made the assumption that Jordan Ryder was a suspect. So those are all on the record. Any notion of it being unprofessional or weird is off of the record. If
Your Honor.
Yes.
Sorry for it. Did I interrupt you?
No, go ahead.
Could you also strike out where the witness that it like they were preset on as guilty?
I'm on the fence about that one. I'll be honest with you, counsel. I will. Here's what I'm going to do. I'm going to, for now, keep on the record that the witness made this assumption, and I will allow you plenty of leeway on cross-examination to challenge how he might know that. All right. Defense counsel, if you have more questioning for the witness, you can proceed. And if you would like to lay foundation, here's what else I'll say, sorry. If you'd like to lay foundation that for some reason he does know about how police investigations work, you are free to do that at this time, but for now, his opinion on the police investigation has been stricken.
I do not want to lay any more foundation, Your Honor.
Okay, then you can just proceed with the rest of the testimony, counsel.
That is the rest of my direct, Your Honor.
Excellent. Prosecution counsel, do you have cross-examination for this witness?
Yeah, sure.
Okay, prosecution counsel, I might ask that you turn your video off to make your audio clearer. Is there any problem with that?
No, Your Honor. Can you hear me clearly now?
We can, Attorney Gray, thank you.
Thank you, Your Honor. May I proceed?
You may.
Cameron Lee, what time did you see the defendant and Parker Page head off to the Lacron Loop?
Well, I don't know the exact time. I know that at about 2:45, I went to go eat my lunch, a delicious salmon sandwich, by the way. And then after I ate lunch and I talked to them, I went down to, they left me behind. And then when I went down to Muskie Pond, it was about 4:30. So I would say they probably went up at about 4 o'clock, but I wasn't checking my watch constantly, so I can't be 100% sure on the timing.
Okay. And you saw them come back around 4:30, correct?
Yeah, at 4:30 was when about 4:30 was when I saw Jordan coming back. And then 10 minutes later, I heard someone else coming back, who I assume was Parker. So I would say at 4:40, I heard someone else come back. And 4:30, I heard Jordan coming back.
Okay. You never actually saw Parker Page come back, correct?
No, I did not. You see, when I was like, I heard her footstep. Oh,
may you please answer yes or no to these questions?
Yes, I have no idea.
Okay, thank you, Cameron Lee. Did you ever hear Parker Page come back? Like her voice?
No, I heard no voices. I only heard footsteps.
During your other encounters with the defendant and Parker Page, did you ever hear Parker Page talk?
Well, yeah, I recall her mumbling a bit under her breath. You know, some things I don't exactly, I think it was something about someone named Corbin. I can't exactly be too sure, but she mumbled it. So I really, I couldn't identify her voice in full.
Okay. But you saw the defendant and Parker Page leave together to go on the hike, correct?
Yeah, yes, I did.
Okay. Let's skip a little till later that night. You said that you heard a truck around 2:30, correct?
Well, I heard a sound that was like lightning, and then, I heard the rattling, and I assumed it was a car/truck. Yes.
That sound was familiar, correct?
Well, it sounded like someone without a muffler on, and my old truck, it didn't have a muffler on, so I recognized the sound.
Cameron Lee, in your affidavit, you said that the truck that you had seen Ryder in sounded like the truck that had left that morning at 2:30, correct?
Well, you see, I only heard a car without a muffler, and I did, when I first saw Jordan Ryder in a red Chevy, I also heard that they did not have a muffler on. So while the car I heard did not have a muffler on, I can't be certain that it was Jordan's car, because I never saw the car on the road. I never saw a red Chevy. I just heard those noises.
Okay, but in your affidavit, you said that you were pretty certain that it was Jordan Ryder's truck, because that's the same noise that you had heard. Correct.
No, you see, if you go to my affidavit, I said if you're going to drive a truck around without a muffler, don't do it at 2:30 in the morning. And I also said I'm pretty sure that the truck never returned, but I never made any mention of me assuming that it was Jordan Ryder's red Chevy.
Okay, and the defense said that Jordan Ryder was out during this time searching for Parker Page, correct?
Well, I mean, I believe that as a witness, I was in sequester, so I wouldn't have been able to hear any of that testimony since I wouldn't have been present in the courtroom.
Okay, Cameron Lee. During this time, early in these morning hours, did you ever hear a voice of a young girl?
In the early morning hours? No, I was at my campsite, dead asleep. If someone had been talking, I don't really think that would have woken me up. I mean, I was only woken up by the truck because that muffler was so darn loud.
Yes, and during that time, you heard no voices when you were awake.
When I was awake, yeah, I only heard the clanging of a truck going down the road. It was pretty loud, so it probably deafened any other noises I could have heard.
Okay. I have one final question for you, Cameron Lee. You were the last person to see Parker Page and Jordan Ryder together, correct?
Well, I don't know that. I mean, when I saw them, they were going at like around like 4:30 or whatever, like I told you. I don't know if they encountered anyone else.
Okay, no further questions, Your Honor.
Thank you, counsel. I need one moment to write some notes and then we can proceed to the next examination. Is there a redirected examination of this witness, defense?
No, Your Honor.
All right, then Mr. Lee, you can step down from the witness stand, and defense, you can call your next witness.
Your Honor, at this time, the defense would like to call Jordan Ryder to the stand.
All right, Jordan Ryder, you may take the stand, and you are presumed sworn and have not been sequestered.
May I proceed?
You may.
Good morning, Miss Ryder.
Good morning.
Can you please introduce yourself to the court?
I'm Jordan Ryder, 33 years old. I'm a mother and Parker is my daughter.
Can you briefly describe your relationship with Parker?
Yeah, we've been close since she was young. We loved going on adventures together. After I went to prison, we still frequently stayed in touch.
How long was your sentence?
I was in prison for about 6 years, and honestly, they were the hardest 6 years of my life. I couldn't see my baby.
Well, what did you do once you were set free?
I immediately went to see Parker and visited her a lot for about 6 weeks. I wanted to help keep her safe, to just protect her.
What did you want to keep her safe from?
My sibling, Corbin, who was their custodian while I was in prison. They only cared about getting drunk or high, and I couldn't let Parker be near someone like that.
Miss Ryder, I know you just mentioned keeping your daughter safe, but I'm going to ask, did you murder your 12-year-old daughter?
Of course not. Parker is my baby and the only person I love. I would never intentionally hurt her.
Now, getting back on track, how did you protect Parker from Corbin?
Well, I went to pick her up from Corbin's and took her to Calkins campground just to free her from the unsafe environment there.
Well, what happened after you got to Calkins campground?
After settling into our campsite, we went to the Lekran Loop path. I wanted her to challenge herself and be stronger than her disease. But she just kept on complaining because she said it was hard to walk and kept insisting on turning back.
Well, how did the hike proceed?
Well, I kept telling her she was stronger than her sickness, but
Parker just said she was tired and angry. I got frustrated with her and took the stick away from her. And then she told me she hated me for coming back into her life.
Miss Ryder, that must be really tough to hear from your daughter. How did you react to this?
I was so hurt, but I realized how much she was struggling, so I decided to let us turn back and head to camp.
What happened once you returned to the campsite?
Well, I hoped letting her return would put her in a good mood again, but she continued to tell me how miserable I made her and how she wished I'd never come back and how I ruined her life. She ended up leaving the tent during our argument in the middle of the night.
How did you react to Parker leaving in the middle of the night?
At first, I wanted to give her space. I mean, teenagers, right? But since it was really dark, I became worried and decided to go and follow her. She wasn't at the campsite anymore, so I just followed the Lecker and Loop trail since it was the only one she was familiar with.
Well, Miss Ryder, what happened while you were on the path?
I just kept following the path and hoped I would find her. Eventually, I got to a part where it looked like someone was standing by the edge of the cliff. I immediately rushed forward, hoping it was Parker.
Well, what happened once you got closer to this person?
As I approached, I saw it was Parker, but her whole body was shaking, and I thought she was crying. I asked her for a hug, but she just ignored me. I wanted to stop the fight and just comfort my daughter, who was clearly upset.
Well, did Parker hug you?
Parker charged towards me. She gripped onto me and was pushing all of her weight on me. She yelled, "I hate you. You're ruining my life, and I wish you were dead." Both of our sides were to the cliff, and she pushed me really close to the edge of the cliff, and I was so scared I was going to slip and fall off the cliff and die, especially considering everything she was saying. So I tried to push her back towards the inside of the trail to keep her safe, but she lost her balance and fell off the cliff.
I'm really sorry, Miss Ryder, but we must proceed. How did you react to Parker's fall?
I was so shocked, it didn't even seem real. I started panicking because of my parole and rushed back to the campsite as fast as I could. I had so many thoughts running through my mind, so I thought a drive would be a good way to get myself organized and thinking logically again.
What happened on your drive?
I tried to talk out loud to myself to try and reassure myself, but it didn't work. So I stopped somewhere along the road, grabbed a napkin, and just started scribbling down my thoughts.
Your Honor, I will be presenting Exhibit 26.
All right.
Miss Ryder, can you see Exhibit 26?
Yes.
Is this a fair and accurate representation of the aforementioned napkin you had written on?
Yes, it is.
Miss Ryder, can you please explain what you wrote here?
I mean, I don't really remember what I wrote. Some notes are from before the trip, like the ones about the supplies in the marina. I wrote the 911 notes because I had no idea what to say to the police. I seriously thought I had to flee the country because I had already been in prison and was still on parole.
So, did you leave the country, Miss Ryder?
No, I realized I was overthinking and not making any sense, so I went back to the campsite to just sleep it off and decided to think about it the next morning.
So, Miss Ryder, what, if anything, happened the next morning?
I woke up to Detective Chesney approaching my tent and was arrested because apparently my baby had gone missing. I was so scared, but I complied with the detective's search and questions and got into the squad car without a fight.
Miss Ryder, was your daughter's body found?
The police found my poor baby at the bottom of the cliff, and she was found dead.
Miss Ryder, did you see your daughter's body?
I couldn't bring myself to see her body. I mean, the last time I saw her, she was alive.
Thank you, Your Honor. No more questions at this time.
Thank you, counsel. Prosecution, is there cross-examination of the witness?
Yes, Your Honor. Ms. Jordan Ryder, you went hiking with Parker Page on July 14th, correct?
Yes, I did.
And you went to Calkins Campground?
Yes.
And you guys decided to go on the Crown Loop hike?
Yes.
And you started the hike around what, 2:30, 3 o'clock?
Around, yes.
And you interacted with Kelly Dews on the LeCron Loop hike?
Yes.
And you wrote all those napkins on that statement? All those statements on that napkin?
Yes, those were all of my notes.
So you did shove your daughter off the cliff?
I did not shove my daughter. She slipped. She slipped and fell.
But you did testify that Parker also was the one trying to push you towards the edge of the cliff, correct?
Yes.
Your weak 12-year-old daughter, who was already injured, was able to overpower you enough to shove you towards the edge of a cliff?
We were close in the first place. I mean, she was already standing by the edge of the cliff.
And your daughter did have brittle bone disease, correct?
Yes, she did.
So there were probably other ways you could have handled it that would have made it so she didn't end up pushing you off, correct?
Objection. This question calls for speculation, as none of the events that she could consider could have happened actually happened.
Response, prosecution counsel?
Your Honor, in this situation, there was many different ways that the defendant could have handled this situation for the fact that her daughter was significantly smaller than her, and there's not only one possibility in this situation that could have happened. So I'm just trying to establish that there were other things she could have done instead of ending her daughter's life.
Your Honor, may I be heard?
Yes.
Firstly, no testimony has come out in court that Parker Page is significantly smaller than Jordan Ryder. In addition, opposing counsel is asking for my client to testify as to what other courses of action could have taken place. This would call for speculation, as none of these events occurred, and they would have to speculate as to what other options they could have taken in the course of their attack when they defended themselves.
Okay, so here's what I'm going to do, counsel. I think given that it's cross-examination and your client is free to say, I don't know, I'm going to allow for this line of questioning I'm going to allow for this question. If you believe that opposing counsel is going to proceeding in the line of questioning that you still believe is improper, you can re-raise the objection.
Would you like me to restate the question, Ms. Ryder?
Sure.
Do you believe that there was any other options that you could have done that would not have resulted in you ending your daughter's life?
I don't know. I mean, in the moment, obviously, I'm fearing for my life. I didn't think about all the options that could have taken place. I was trying to defend myself.
Before in the hike, there was places that there was aggression between the two of you already, correct?
Yeah. She told me that she hated me multiple times.
Where she was jabbing the hiking stick at you and you in turn jabbed it at her, correct?
I just took the stick away.
So in that case, you were able to handle this child's rage. And with the fact that she did have brittle bone disease, it would have been easy
Your Honor,
to.
this is a question.
Sorry, could you repeat the objection?
This is a compound question. Opposing counsel is asking if they were able to handle her rage and if she had this brittle bone disease and how it affected it at the same time.
I tend to agree. Attorney Johnson, can you break that down into 2 questions, please?
Yes, Your Honor. You were able to previously handle Parker's signs and acts of aggression, correct?
Well, she was merely pestering me with her stick. Yes.
Okay, so when you shoved your daughter off the cliff, you had no problem. You walked away.
Yeah. Question is argumentative. Nowhere has my client testified to shoving my client off the cliff and has consistently testified that it was a fall. To say that Parker Page was shoved off the cliff is an incredibly argumentative statement.
How can it be argumentative, Your Honor, if I have not even stated the question yet?
Your Honor.
So I'm gonna uncross some wires on this really quickly. What's happening here is that the attorney is testifying because they are stating an occurrence that no witness has testified to. So I would advise you, Attorney Johnson, to stick when you're paraphrasing what happened, when you're kind of leading into your question, to make sure that the events you're talking about are things that this witness has testified to, or considering that they were not sequestered, that other witnesses have testified to, but you yourself cannot testify as the attorney.
Yes, Your Honor, thank you. Miss Ryder, once your daughter fell off of the cliff, you did not do anything to try to help her, correct?
Well, first off, she fell off a cliff and I was in such a state of panic. And I mean, I'm an ex-con. Who knows if they'll falsely accuse me? I was just so scared.
But in a moment when that happened, shouldn't you have been solely focused on trying to save your daughter's life?
Well, I don't know. She slipped and I was just utterly shocked. Shock was all that was running through my body. I couldn't process what was happening.
No more questions for this witness, Your Honor.
Thank you, counsel. Defense, do you have any redirect examination of the witness?
Yes, I do.
You can proceed with the redirect examination when you're ready.
Miss Ryder, what was going through your mind as Parker fell?
I just couldn't believe what had happened, and I was completely out of it. I had no idea what to do, how to handle this situation, and I was thinking about, how could I be perceived in this situation? I was just confused.
Your Honor, I asked for permission to present Exhibit 26.
Granted.
Actually, you know what? No more questions at this time, Your Honor.
All right, so there will be no Exhibit 26?
No.
Excellent. Okay, let's see. We are very good on time. There are no more defense witnesses, am I correct about that?
No, Your Honor.
Okay, so I will look to a 5-minute recess before closing arguments. I have that it is 28 after the hour, so let's convene at 33 after the hour.
That sounds great, Your Honor.
All right, thank you. What matters now is that our closing attorneys are present. So Can I get the attorney who is doing the closing argument for the prosecution to tell me if you're here?
I'm here, Your Honor.
Okay. And can I get the attorney who is doing the closing argument for the defense to tell me if you're here?
I am present, Your Honor.
All right. Then as soon as you're ready to proceed, Attorney Song, you can begin your closing argument.
May it please the court. Members of the jury, on July 14th, 2018, the defendant was just so angry and proceeded to shove her 12-year-old daughter, Parker Page, off of the Leckrone Loop Trail off a 40-foot cliff, where Parker tragically plummeted to her death. Members of the jury, you were presented with a lot of evidence throughout today's trial, but one thing was repeated. The defendant did push her daughter backward, who fell 40 feet to her death. As the prosecution, we bear the burden of proof today to prove beyond a reasonable doubt that the defendant pushed her daughter, Parker Page, off a cliff, causing her death. To have knowingly caused her daughter's death, the defendant must have been aware of her conduct and the dangers of it. The defendant was aware that Parker was not any other 12-year-old girl because her daughter had brittle bone disease, which made her more susceptible to lung problems and bone fractures, even from minor falls. The defendant was unable to accept the growing reality of her daughter's debilitating disease. Rather than working alongside her daughter and her condition, the defendant chose to push her daughter into a situation that she was not prepared to be in. On July 14th, we know what happened. The defendant was walking with her daughter on a trail that is steep and grueling and not one that you take a child who has brittle bone disease on, especially if it was the child's first trail. The eyewitness, Kelly Dews, told us the defendant was fighting with her daughter moments before shoving her daughter off the cliff. The defendant's daughter was trying to let her voice be heard, to communicate that she didn't want to be on the Leckrone Loop Trail because it was rocky, uneven, with steep drop-offs right next to it, in addition to the fact that Parker had a limp. But the defendant only became more enraged, disappointed, and resentful, hearing the words come out of her daughter's mouth. This led to the defendant reaching her breaking point, shoving her daughter off the cliff. We know exactly what the defendant did after her daughter died. She did not attempt to call the police. She did not try to save her daughter's body. Instead, she goes where? To a cafe to map a plan of escape. You heard from Detective Chesney about the napkin, which shows the defendant's plan to act surprised, and the defendant's explanation for her daughter's death, missing. It crosses out the true explanation to the death of her 12-year-old child. That is, the defendant was just so angry. Members of the jury, in a few minutes, the defense counsel is going to appear and say we did not eliminate doubt that the defendant killed her daughter. But we don't have to eliminate all doubt. We only have to eliminate reasonable doubt. It is not a coincidence that the defendant had to circle missing. It is not a coincidence that the defendant had to cross out 911. It is not a coincidence that the defendant crossed out, I was just so angry. The evidence does not pile up against innocent people because the defendant is not innocent. So when the defense tells you about their theory, the prosecution asks if you can see the defendant's story to be reasonable, or if it's an extension to the defendant's plan of escape. There's only one reasonable explanation today. The defendant pushed her daughter, Parker Page, to her death. Find the defendant guilty of aggravated murder. Thank you.
Thank you, counsel. Defense, when you're ready, you can begin your closing argument.
May it please the court. I hate you. You're ruining my life. I wish you were dead. Enraged, Parker Page charged towards Jordan Ryder, gripping onto Jordan with all of her force and pushing all of her weight on Jordan. The two were forced to the edge of the cliff. Fearing for her life, not only due to Parker's rage, but also due to the attack, Jordan Ryder did her best to protect both herself and her daughter. Jordan's attempt to push Parker off of herself did not pan out properly. Parker lost her balance, and when Jordan Ryder stopped Parker's attack, and all Jordan was able to see was her daughter slipping off the edge of the cliff. This is self-defense that came at a mother's expense. After being separated from her daughter for 6 years, Jordan Ryder was released early from prison and gained her freedom. While separated, Parker was under the care of Jordan's drug and alcohol-addicted sibling Corbin. Wanting to use her freedom to help her daughter add more experience and activities into her life, Jordan decided to take Parker with her to Calkins Campground. Upset at the newfound care and impact of now actually having a parent's guidance and input in her life, Parker acted rashly and attacked Jordan. With the fear of a past criminal record, Jordan Ryder panicked and did not know what to do or what to say to the police. Through the course of the trial, you have heard two perspectives, one that attempts to showcase Jordan Ryder's guilt and one that highlights her innocence. Let me remind you that the prosecution carries the burden of proving their case beyond any reasonable doubt. Prosecution alleges that Jordan Ryder had the means, motive, opportunity, and intent to murder her 12-year-old daughter. Through the course of trial today, it has been made incredibly clear that the prosecution has utterly failed to meet their burden. Prosecution relies on three main sources of evidence in today's trial, namely the testimony and investigation of Detective Chesney, the testimony of Kelly Dews, and document-based exhibit evidence. The prosecution has attempted to paint a story that points to Jordan Ryder's guilt. However, it is exactly that, a story crafted from the work of a detective who mostly has field experience with traffic violations. Detective Chesney has only had a year's training in alleged homicide cases by the time of this investigation. As shown by the evidence, the detective did not even do their job correctly. Detective Chesney came up with 3 different theories of what this case was, and all 3 are incorrect. At first, Chesney believed that this was a missing persons case. After going to speak to Corbin Dallas about Parker Page's alleged disappearance, Detective Chesney soon believed that this was a kidnapping case, and that the suspect was Jordan Ryder, Parker Page's mother. Jordan Ryder was Parker Page's only living parent and had complete parental rights over Parker. Next, Detective Chesney suddenly came up with a murder theory, which, like the other theories, is incorrect. Detective Chesney's gross incompetence impacted today's case. She even testified today to not knowing or understanding the situation around Parker's custody and parental rights. Detective Chesney had to be guided through their job of tracking Parker Page's location by an intoxicated Corbin Dallas. Rather than asking Corbin for efficient methods of tracking Corbin, Detective Chesney decided to conduct a 25-minute search for a missing child. After Detective Chesney failed to locate Parker, Corbin then advised Detective Chesney to use Parker's eCloud software and account to track the location of her phone. Furthermore, Your Honor, Detective Chesney has not found a single piece of evidence that contradicts Jordan Ryder's testimony. Detective Chesney also failed to examine or study the self-defense theory of today's case. Second, prosecution relies on the testimony of Kelly Dews, an individual who has admitted to having a tendency to exaggerate. This tendency is displayed when Kelly Dews makes the ridiculous claim that based only on one interaction with Parker, they noticed Parker's distinctive voice. Through a small comment, Parker whispered to herself through her teeth. Later, Kelly Dews heard some screaming and decided, based on having heard Parker's small whispered comment, that the scream came from Parker. A whispered comment and a scream. Further, Kelly Dews was meant to pay for their stay at Armani Rodriguez's cabin, but failed to do so. When the body was discovered, Kelly Dews heard the police saying that Jordan Ryder had killed Parker, and this was prior to them completing their investigation. Kelly's testimony also supports the fact that Jordan was attacked by Parker. Kelly extensively testified to witnessing the pair arguing and hearing Parker say that she hates Jordan. Corbin Dallas also saw the pair arguing and also testified to the fact that Parker returned to the campsite after Jordan Ryder. Finally, the prosecution puts the most weight on two documents: Exhibit 26, a napkin on which Jordan Ryder had taken notes, and secondly, Exhibit 25, information regarding Parker's life insurance policy. These documents, however, perfectly show how Jordan Ryder had reacted to the events of the night. When Parker fell after Jordan Ryder defended herself from Parker's attack, Jordan Ryder panicked. Jordan Ryder had recently been released from prison and believed that she may need to flee the country because she violated their parole when she went to the campground. Also, the impact of Parker's fall resulting from Jordan Ryder blocking the incoming assault from Parker caused Jordan Ryder to act irrationally, to panic. She planned what to tell the police when she spoke to them. She planned to admit that Parker's fall occurred as an accident, believing that it was her fault that Parker fell. In her panic, she decided that she would tell the police her daughter was missing, believing that she may need to leave the country. Your Honor, it is clear that the prosecution has failed to meet their burden of proof beyond a reasonable doubt. The prosecution alleges that Jordan Ryder is guilty of aggravated murder. For the purpose of today's case, that would be murder with intent to kill an individual under 13 years of age. Today's case is not a murder case. It is a tragic case about self-defense. Jordan Ryder was attacked by Parker Page, and she did her best to protect both herself and Parker. In her attempt to defuse the situation and stop Parker's attack, however, Parker slipped and fell off the cliff. Beyond this, there is reasonable doubt in the case, as all of the document-based evidence and evidence brought into the record from Kelly Dews regarding placing Parker and Jordan together is circumstantial evidence. In addition, Detective Chesney failed to provide any evidence that contradicts any of the testimony that Jordan Ryder has given and the fact that this is self-defense. Your Honor, do not let a misappropriation of justice take away the one thing that Jordan has left, her freedom. Your Honor, find Jordan Ryder not guilty of aggravated murder. Thank you.
Thank you, counsel. Prosecution, do you have any rebuttal, or are you finished with your closing arguments?
Yes, Your Honor, may I use the time for a rebuttal?
Absolutely.
Members of the jury, defense counsel says the defendant was doing her best, that there's reasonable doubt because the defendant has no motive. We don't have to prove the defendant wanted or intended to kill her daughter. We have to prove beyond a reasonable doubt that the defendant did push her daughter, Parker Page, to her death. If the defendant did care for her daughter, if the defendant did love her daughter, why would a loving, caring mother not call the police? Why would they not look for her beloved daughter's body if all of this was an accident? She should do anything to save her daughter. But instead, the defendant chose to go to a cafe, to take a napkin and plan how to cover up her actions, not an accident. Members of the jury, you heard about Le Grand Loop. The defendant admitted to its steepness and uneven path. The trail is narrow and with drop-offs right next to it. You heard about the defendant's near constant fighting with her daughter while on the Le Grand Loop. The defendant was angry enough to jab her daughter with her hiking stick. The defendant was just so angry that she shoved her daughter off the 40-foot cliff. Kelly Dews, the eyewitness, did hear what other officers said. But at Calkins Campground, there were Midlands Fire officers, EMT Rogers officer, and K9 officer Hemsley with police dogs at the ground. There is no proof that the officers that Kelly Dews heard speaking were in the same workforce as Detective Chesney. And you heard today about the napkin, the plan that the defendant crafted after she shoved her daughter off the cliff. Members of the jury, I want to be clear that the defendant wrote down, "I was just so angry." But she realized it wouldn't be enough. It wouldn't be enough to cover up her actions. So she circled missing as the best story to tell. There is only one reasonable story. There is only one reasonable suspect. Parker Page is not responsible for her death just because the defendant was just so angry. Members of the jury, at the end of today's trial, it's your duty to look at the totality of the evidence. That means you can't focus on one point, on one time, on one piece of evidence. You have to look at the totality of the evidence. And the totality of the evidence points at the defendant for being the only reasonable suspect. There's eyewitness reports of fighting. There's Parker with brittle bone disease. There's a hiking stick the defendant was not afraid to use. There's the body of the defendant's daughter. There's the time in between Parker's death and the defendant not calling the police. There's a map of escape that crosses out, "I was just so angry." All of that is definitive proof. The defendant is responsible. Hold the defendant responsible and find the defendant guilty. Thank you.
All right, well, that concludes today's trial in the case of the State of Midlands versus Jordan Ryder. I'm gonna ask for like 2 minutes to make sure my ballot is filled out. So do a little stretch, pat yourself on the back for being done, and then I will come in with comments.